Connecticut landlords need to understand their state's entry rules before stepping foot inside a tenant's unit. Connecticut law is clear about what's required and the consequences for ignoring those rules. Welcome to tenantscreeningbackgroundcheck.com. Here's what Connecticut landlords need to know about right of entry. Connecticut requires landlords to give reasonable notice before entering a rental unit. While the statute does not specify an exact number of hours, Connecticut courts and legal practitioners generally treat 24 hours as the standard for reasonable notice. Giving less than that puts you at legal risk. Entry must take place at a reasonable time, which is typically interpreted as normal business hours on weekdays. Showing up at 7 a.m. or on a Sunday without tenant consent, even with advance notice, could be considered unreasonable. Connecticut permits landlord entry for making repairs or improvements, inspecting the property, showing the unit to prospective tenants or buyers, and responding to emergencies. If the tenant has abandoned the property, entry is also permitted. Emergency entry without any notice is allowed when there is an immediate threat to the property or the tenant's safety: fire, flooding, and similar urgent situations. Connecticut's landlord-tenant statutes emphasize the tenant's right to quiet enjoyment. Repeated or abusive entry without proper notice can expose a landlord to claims for damages and may give the tenant grounds to terminate the lease. For Connecticut landlords, best practice is to give written notice at least 24 hours in advance, state a clear reason for entry, and schedule visits during reasonable daytime hours. Document your notices to protect yourself in case of any dispute. For complete landlord resources and tenant screening tools, visit tenantscreeningbackgroundcheck.com.